Good morning, everyone. Shall we start?
Okay, yeah, we can start.
Okay, so welcome to the international panel of the sixth student conference in theory, philosophy, and sociology of law on the topic judiciary between law and politics. Now, my dear colleague Bojana Todorovic will speak in front of the Faculty of Law.
Good morning, everyone. I would like to welcome you all to the University of Belgrade Faculty of Law. When I looked at the agenda of the conference, I have to say I was very impressed, first by the topic, judiciary between law and politics, the attempt to protect the judiciary from the influence of politics is an important and also a perpetually challenging task. So I'm very happy that you have all embarked on analyzing different aspects of this topic. And it is very interesting to see that it is not a topic that one country is dealing with it. It's a transnational issue and problem. And also, having taken a look at the topics of your papers, I have to say that they all seem very interesting and very mature. So in my name and on behalf of the Faculty of Law, once again, I would like to welcome you and wish you a very fruitful conference.
Thank you. Also, as an executive editor of this conference, I would like to thank you for being here with us and making this conference possible and hopefully successful. But I would also like to acknowledge the efforts of my colleagues, Professor Bojan Spajić, Teodora Miljojković, Petar Mitrović, Nikolina Nedeljković, and Stefan Rakić, who have done an amazing job in organizing this event. Yesterday, we have tackled some issues concerning judiciary, but mostly in regard to the Serbian constitution and domestic law. Today, however, I hope that we will take our discussion to another level, more theoretical level. And with that being said, I invite Meir Yarom from New York University School of Law to present us his research on the topic, the logical basis of legal inconsistency.
Thank you. Thank you very much, everybody, and thank you for our great hosts and their hospitalization, which has been a pleasure. It's a great honor being here. I'll just set my watch, so 15 minutes would actually be 50 minutes. And of course, I thank both Anna and Nina for being part of this session. So let us begin. What I want to do in my presentation is very briefly two things. First, I'll try to provide some context for my paper, namely to embed it within a larger inquiry which I'm pursuing concerning the interplay of logic in law. Secondly, I'll attempt to clarify the key tenets of the argument, because as most people in the room have not read yet the paper, hopefully that will sharpen the ensuing discussion, and so I'll keep my comments as brief and accurate as I can. So starting with the context, the paper starts by assuming, I take for granted that is, that law is a systematic enterprise which regulates human behavior. Granting as it is that not everything can be done by law. Law is not completely irrational, that's the way I take it. And not everything comes, or everything goes, as they say, when it comes to ruling via law. And this systematic nature of law, well known to jurists, oftentimes disputed or denied altogether by non-legal actors, especially in their attacks that have been already suggested on various judiciaries around the world. This nature entails that there are limits on what legal systems can demand from subjects. Now, my claim during my general research is that such limits are reflected in two central vehicles, namely coherence and consistency. In other words, what I claim is that because law, or rather it is because law is systematic, and to the extent that it actually is, that these two notions give concrete meaning. Without the systematic nature of law, it would be difficult to actually ascertain what it means to either say of legal materials that they are coherent or consistent. And this brings me to the first notion, which I do not discuss in the paper very briefly, and that is coherence. It is the more ambiguous notion of the two. And many, at least in the Anglo-American discussions, have described this vague notion as the consistency of principle between legal materials, namely that they have to fit. However, as I mentioned quickly in the paper, it is not entirely clear what it means for legal materials to fit or to be consistent in principle. These are essentially metaphors that, as I mentioned earlier, have to be poured, or rather we have to pour content into in light of the systematic nature of the given system with which we are dealing. Now, I only mention coherence in order to contrast it with consistency. Generally speaking, things are thought to be different for the requirement of consistency. We borrowed it from classical logic, and it originally means that we have a state of non-contradiction between units or propositions. Now, this is a clear and precise definition, and this is an important point, and because it is such clear and very strictly defined, it holds considerable justificatory potential. Namely, calling two legal rules inconsistent normally transmits sheer irrationality on part of the relevant actor, and this means that legal interpreters, especially courts, can harness legitimacy to carve abuses of legal power. So generally speaking, the structure of the argument goes, look, if you're not able to show that what you're doing is at least not inconsistent, you surely are doing something wrong, right? Now, this is a very important part in my research because my claim is that the problem starts when we reflect on what consistency in fact presupposes. Namely, it presupposes that the nature of law is logical. So the essential claim in my paper is that it is not clear that legal systems can indeed live up to that ideal, namely to being logical. It is not clear, in other words, that we can employ a genuine requirement of consistency in legal systems. And this, in turn, leaves legal interpreters, especially courts, vulnerable to allegations, which we in fact always hear, concerning subjectivity and usurpation when they try to bar legal uses of power. So that's the general context, and from this context we have two ways out of the problem. The first is to redefine the notion of consistency. We can say, look, we know that it was, originally speaking, coming from logic, has been a very strictly defined requirement, but we can make do with some other quasi-definition or quasi-logical definition of consistency. That's the first route. The second is to account for a logical usage of consistency within legal systems, and namely to show that law can live up to the ideal of being a logical endeavor. So the first way is what I call in the paper the intuitive response. This response, which if I were a legal psychologist, I would say it mostly is grounded in denial, hinges on the claim that contradictions between rules can be gauged by what people usually refer to as heuristic or juristic common sense, right? And therefore, there shouldn't really be a problem to implement the consistency requirement. My problem with this response is that I think it begs the question. I think it ignores how difficult it is to actually assess when legal inconsistencies arise. And I want to give a couple of examples which are not present in the paper for us to reflect on. So I'm going to present three pairs of legal rules, or imaginable legal rules, and I want to show that it is not necessarily clear that we have inconsistency between them. So firstly, think about the first rule, which is embodied in the normative sentence, citizen A, bless you, is obligated to pay tax. And the second legal rule, citizen A is not obligated to pay tax. This, usually we would say, is as clear a contradiction case as perhaps can be. However, what I try to show in my paper, specifically in pages 15 to 17, is that it is not clear that in fact we have a contradiction here, because it is not clear what precisely the second rule, namely citizen A is not obligated to pay tax, what exactly it means. Why not? Essentially, the concept of negation is a descriptive concept. It means not descriptive proposition. We don't necessarily have an equivalent or a translation or a way to account for the same concept in prescriptive discourse. This is a problem that von Wright, which I allude to in the article, has already reflected on several years ago. So this means that our rule might mean, one, that there is no prescription within a given system concerning A's tax paying, or alternatively, and that's a different proposition, that there is a prescription in that system, but that this prescription either ordains that A may or may not do so, or ordains that A may be exempted, and so on and so forth. The conclusion is that it is not precisely clear how we demarcate the negation concept, and therefore whether or not we actually have a contradiction between two legal rules which normally everyone would take to be contradictory. Consider quickly next couple of examples. First, citizen A is obligated to pay tax, and the corresponding sentence citizen B, who is similar in relevant respects to citizen A, is not obligated to pay tax. Now note here that we don't have necessarily the same agent, right? Because we have citizen A and citizen B, but we do have some kind of a mechanism which purports to, as it were, offset this disparity by saying that they are relevant in similar respects. Here again, we have a non-logical usage of the concept of contradiction, and if we go back a bit to coherence, we can ask ourselves what really is the distinction between saying that these two rules are incoherent and saying that they are inconsistent. It is not clear precisely what it means to say that they are inconsistent, as it were logically. Finally, consider the case when citizen A is obligated to pay tax by January 1st of each year, and in order to pay tax, all citizens must submit official forms to be obtained from tax authorities. Now consider the second rule, saying that, or promulgating that tax authorities are obliged to provide all citizens with the required forms by February 1st of each year. Now, do we have any inconsistency in this regard? Once again, whether or not we do is unclear, and even if we do say that we have an inconsistency there, it is questionable whether it is the same kind of inconsistency as we have perceived in the first couple of examples. Eventually, I reach the conclusion that our inability to clearly and assertively sift through these and similar examples renders the intuitive approach problematic, and therefore that we have to account logically for what it means for rules to be inconsistent if we are to protect unelected interpreters from allegations concerning both subjectivity and usurpation of power. This brings us to the main counters of my argument, which I will flesh out very briefly. The second way, namely, of accounting for law's logical nature is what I'm taking in a bifurcation, which means that I'm looking into what R.M. Hare is doing, and thereafter I'm looking into what von Wright is doing, and I'm trying to assess whether or not they are successful in what they're doing. I'm trying to assess that based on three difficulties which I identify. First, that logic is considered to be propositional. It is grounded in a relation between propositions, and many theorists, including theorists from South America, but not only, have held that there are no normative propositions, a fortiori that there are no legal propositions. So if we don't have legal propositions, it is unclear how logical interactions can actually be conceived. Secondly is the problem of truth value. Logic is generally considered to be grounded in propositional relations transmitting truth. Now, if norms, as we all know, cannot obtain truth value, they cannot be true or false, it is unclear how logical relations are supposed to work, even if we grant that there are normative propositions, namely even if we hop over the first difficulty. Finally, the third difficulty, which is not unrelated to the ontological ambiguity which I mentioned, is that the manner in which legal materials are articulated many times leads to uncertainties concerning the precise proposition a given rule transmits. We saw that in the couple of examples I just mentioned. This difficulty I labeled the uncertainty of extraction, and it was seen at work when we surveyed our examples. Given these difficulties, I assessed the first attempt to account for logical relations, which is Hare's account of the logic of imperative sentences. An imperative sentence is a sentence which essentially says, do something, or you must do something, or I ought, or you ought to do something, and so on. It is a category which is adjacent but not similar to normative statements, and Hare's argument, which is very intricate, essentially boils down to the claim that if we analyze these statements, and I show how in my paper, we can see that the phrastics, which is a part of them, in these phrastics, through these phrastics, there runs a quality which he calls earnest meaning, and it is this quality, which is an analogy to truth, which grounds propositional relations between sentences. It is quite an ingenious solution, but essentially it means that we postulate that the category of earnest meaning, which flows through phrastics of sentences, is equivalent to truth, and we then work out the concrete details of the logical system. This principled postulation, however, and this is my objection to Hare's account, cannot enjoy endless credit. What I mean by that is that we have to ask Hare and ourselves what grounds the possibility of interacting imperative sentences. And if we see that we don't have a clear criterion for discerning when a contradiction actually ensues between imperative sentences, then even if the argument, as articulate and brilliant as it is correct, it does not alleviate the tensions of actually safeguarding legal rationality. So by attempting to demonstrate that the imperative contradiction is not a logically deduced concept on pages 16 to 18, I claim that a logical system of imperatives must rest on choice on part of the beholder. Now, if that is the case, we reach the exact same problem with which we started, namely, even if the argument works, it does not surmount the difficulties of shielding the discretion, or rather the lack of discretion, of official interpreters. This leads us finally to von Wright's norm proposition solution. Now, this solution is probably the most famous attempt at devising a logical system of norms. He calls it the ontic logic. And the root of the problem is similar to the challenge we already posed. We want, on the one hand, our normative system to be rational, or at least not latently irrational, and we thus venture to elucidate its systematic logical nature. But norms, like imperative sentences, are not considered to have truth value, and thus they cannot enter logical relations. Von Wright's solution offers a bypass. He transforms norms into norm propositions which report the norm's existence, and then he sets out a logic of norm propositions, as it were. The latter can enter logical relations, just like descriptive propositions do, and can therefore ground the ontic logic. After schematically outlining this idea, I cast doubt on the analogy that von Wright draws, because essentially my claim is that, you cannot necessarily claim that the ontological premise that von Wright grants to his solution actually holds. What I mean by that is that on von Wright's analysis, and for this analysis to work, we must presuppose that all norms are language dependent. All norms are in a category of wills, and they are promulgating the wills of the authority, and therefore they are essentially the enunciations or the words which are taken to promulgate them. As I mentioned, on this analysis, all norms are language dependent, with prescriptions, which he takes to be the prime category, are the promulgated will of an authority. If this ontological premise is correct, we could arrive at a logical system of norms, but the problem is that I'm not certain that this characterization holds. As I discussed on the last couple of pages, customary norms are not naturally congenial to such a representation which reduces them to language. So this means two things. A, if we take the norm proposition solution as our solution to the dilemma, most, or at least a big part of our working legal systems cannot be accounted for by that solution, namely, we cannot account for norms which are not canonically formulated. And secondly, this casts doubt on generally the premises of the normative ontology of von Wright, and therefore generally casts doubt on his solution. Ultimately, I conclude with the hope that more work on the ontological basis of norms would allow us to account for their logical relations. Thank you very much, and I look forward to both the discussion and the comments.
Thank you, Mayor, for this quite comprehensive analysis. Now I invite Mina Kuzminets to provide us with her comment.
Well, I would first like to say that our colleague also has comments on this paper. So if he wants to ask something first.
No, actually.
Okay.
No, I just have, because I think you have done a proper comment on each, because I just read it last night. I got the paper, so whatever I could frame, and I had certain questions when your paper was very well arranged, and certain things, when you talk about prescriptive norms, and a judge is when we relate it to the topic with the politicization of judiciary. So what is the source to find out what is the right choice to make for a judge, and what is the source? Is the personal choice of a judge, or that source which allows the judge to make a choice rest within a text? For example, when you mention about this case that you mentioned in your paper about a parent should take care of the child, and also the state should do it. So there is a intuitive inconsistency when you see it. But if there is like when we work as a lawyers and we see there's a law always carries an objective. So that objective always makes a judge to look at what the law intends to say. So if we look at the intuitive way the law can be read in this case, one would say that there is a contradiction because a father should take care of the child, but at the same time, the state should also take care. But one would say, okay, but like if you look at the law, the situations can be where if the child is supposedly orphan or he's without any parent, then the state would intervene. So what are the grounds or what are the sources on which you would say that there is a source from which a judge, a decision maker, should make those legal propositions that can be translated into consistencies when it comes to the decision making for a judge? And when you talked about the when you to, I mean, and also when you talk about the fact that there is a language when it comes to decision making and the language that defines what the law should be. And so my question to you is that what is the role you think that language plays and what is the role of discretion when a judge is supposed to make a choice? For example, like there are cases in US and India when the word shall is interpreted to mean may, and may is used as shall, and that discretion is vested to the judges to make in a proper conditions where they would see, okay, what are the facts of the particular case, and they would relate it to a particular fact. So my question to you is that do you think that prescription can be case wise or it can be generally applicable for every case, or it's specific to the case and prescriptions might change from one case to another? And this was, and then my last question would be when you talk about right theory of legal proposition, a fact, you call it fact, normative fact and normative proposition. Do you think that a normative fact can be translated in a differently worded or differently intended statute when you give it a meaning through a proposition? A fact, there's a normative fact and there's a normative proposition. So, do you think the judges enjoy the discretion when they are translating the fact into a proposition? And while doing so, a judge can be, like criticized that he has taken a stand which is pro the government or pro someone which would make him look political on the bench. Or it can be something because these days, like when you see that like in a democracy, mostly the judges are supposed to act on behalf of the government, and government always to let the court decide on the political sensitive issues. So in that situation, our judges, when they use their prescriptive sense of justice, when they say what is right and what is wrong, they actually leave themselves open to the public to criticize them. Either they are pro the government or against the government, or for the people or against the people, or judges should refrain from making their own prescription, which is their own independent view, which do not find a legal anchor to say so, to give like if you have read Justice Scalia would always go for an originalist interpretation. He would always anchor his argument on the fact that this is not what the law intended. And if the law did not intend so, the government or the court should refrain from doing what was never given to them as a power. So what are the things that a judge should do in situations where they are in a place where using their own sense of justice can place them in dangers of being criticized, and giving a literal interpretation as it is to the law would make them someone who are pro government. So I'm just like my entire comment is based on a situation of a judge where he is to decide, and he has he has no legal anchor to support an argument, but judicial creativity to a length where judges now have given so many new concepts that they are open to be criticized, and also the fact that a judge understanding of a notion is very different from a judge who would understand it later. For example, like I'll give you like this concept of unconstitutional constitutional amendments. Like you see how it's interpreted in India, in Israel, in other parts of the world, and how it has been came to interpret in most of the Latin American countries. Like for example, Honduras made made a claim that it is something that you can amend the constitution and like people will stand ultimate, which is the government. So I mean, basing entirely my question to you is this: that how a judge is placed and how he is open to be criticized for being political and apolitical, pro government or against government, and how a sense of prescription would make him open to that criticism.
Thank you. This was our special guest. I wanted to, from the Supreme Court of India, but Mina stole my introduction. Never mind that. And although you didn't have enough time, which I'm really sorry about, I think that you made a substantial and really important comment. And now I, once again, invite Mina Kuzminets to provide us with her comment.
I'm sorry, I didn't want to.
Of course, it may. It's okay with that we hear all the comments and then afterwards you can.
Yes, thank you.
Well, my first question relates to notions of legal coherence and legal consistency. Even though you have answered to some extent in the paper itself, and now I think it is still necessary to have a more detailed distinction between the two. So it's very short, but I think it's necessary to just give it more precisely. And my second question is by the end of page 4 in your paper, when you speak about the obscurity of legal inconsistency, before the conclusion that inconsistencies between rules, in other words, come in all shapes and sizes, you say that we would likely want to label an exclusion of one person from a benefit granted to similarly placed another as inconsistency. So you also mentioned this, but to me, what you say here could be called or could be an act of discrimination. So what is the relation? You have also to some extent spoke about it, but I think it is necessary to speak more detailed about this question. Some of the things you have answered now, so there is no point in asking them. Thank you for that. Also, on the page 18, I will not quote it because it is quite long, but what I concluded is that it is generally perceived that contradiction is a logical category. So is this only true of an indicative contradiction, but not of an imperative one? So I think it is necessary to answer that as well. Also, does it mean that am I too fast?
No, please.
Okay, does it mean that inconsistency and contradiction are not objective but rather subjective categories? Also, one more question that I think it is important is the question: what is the relation between legal inconsistency and hierarchy of norms? So, what is the relation also between legal inconsistency on one side and level of generality of norms, like the lex specialis rules, and also timeline of adoption of norms, like lex posteriori rule? Well, out of all the questions I had, I marked these ones as the most important ones after the elaboration today. Was I too fast now? I was just jumping from one question to another. But I think that those are some crucial moments that need to be explained more precisely in a more detailed manner.
Okay, maybe the floor is yours once again.
Thank you. So thank you both for great comments. I think it would be best. To start with an observation that you make, Mina, and then I'll stroll through the rest of the comments, which I think all of which are very helpful, and I hope I can quickly do justice to all of them. So, your fourth question is are the notions of inconsistency, contradiction, and so on subjective or objective categories? And it's funny, but that's the sentence I wanted to open up my presentation with, because I think it hits the nail right on the head. That's the question. To the extent that we have an objective standard here, I think, or I claim, that it would be much easier to safeguard legal decision making. So I guess the entirety of my discussion is located as an endeavor of trying to show that A, subjective accounts of legal inconsistency fail or they are insufficient. This is what I call the intuitive response, right? We have a common sense view. And this also relates to the questions that you made, which are very pertinent, and I'll get to in a second. And essentially, I try to question whether or not the objective standard that we currently use most eminently here as informed rights indeed carry the full weight of everything that we try to press upon when we say legal rationality or legal objectivity, these huge words. So this brings me to your comment, and I think it's a very important one. So what I want to say is two things, and this will also connect to the distinction between coherence and consistency, which mean I think you rightly noted is not sufficiently elaborated. My general doctoral project is on coherence, not on consistency. And I define coherence as intelligibility induced by unity. And I have a very large and boring chapter on precisely these notions, which I did not include here. But I guess the central idea and the central claim, and that answers, I hope, the question of discretion, is that what consistency is meant to do is to shield against allegations saying you are using your discretion, you're not playing objectively. On the other hand, coherence, I think, also tries to, as it were, oscillate between objective and subjective accounts, but to try and push more towards objectivity while not being confined to a logical, strict notion of decision-making as grounded in a legal pattern. Because as I mentioned earlier, both notions, both consistency and coherence, are essential reflections of saying, hey, you can do that because there's a legal pattern. Now, the distinction between the two notions is that one says this pattern is logical, the other says, well, it's not logical, but it's sufficiently regimented for us to say that's a foul. And that's not a foul because me, the judge, who's a political actor, the mouth of the law and so on, says so. It's a foul because of the objective pattern of our legal system. And I think that these, as it were, combined comments are very important to the understanding of what I'm doing, and I definitely should embed it, at least in the context of the paper. So moving on to the three more specific comments by Mina. So first, I think the coherence consistency, I hope it's clear what I mean when I distinguish between the two. Now you mentioned the question of inconsistency versus discrimination, which I think is super important. I unfortunately didn't have a lot of time to actually go into. I think that many people would say that discrimination is a case of an objective standard, which we must confine legal officials and political power to. To your question, I guess my answer would be that just like inconsistency or the notion of consistency between legal materials is taken to be, or we hope that it is taken to be an objective standard, I think that the very same can be said when we think about both discrimination and hierarchy of norms, because both accounts, this is discrimination, and this is in a hierarchy of norm, a fair or an unfair usage of power, they supervene on the idea that you have contradictions. So really, the question becomes whether or not we can account objectively, yet again, for inconsistencies. Now, moving forward, you mentioned that there's a question between the idea of an indicative and imperative contradiction. I fully agree with you. I think that there is a distinction there. Many people disagree, by the way. But I think that it is important to mark out that there are differences between the indicative and the imperative contradiction, and essentially a lot of the problems which we face in decision making, especially in democratic courts, turn on that problem of clearly saying whether or not there is such a thing, logically speaking, as an imperative contradiction. As I said, I believe that it is difficult for us to show that yes, but it is also imperative that we at least try to account in what sense we can put inconsistency on an objective pedestal rather than as another tool in the judge's discretion, as was mentioned. Finally, the legal inconsistency and hierarchy of norms. So that's a very, very difficult question. I think also Victor's paper relates to that, right? About the feasibility of norms.
Yes.
So I think I should definitely look into that. I'll be completely frank, I've not yet fully disentangled that idea. My intuitive response would be that in the hierarchy of norms, once again, to the extent that what you're envisaging is a logical relations between norms, I think that the comments of the paper apply, and I guess we will hear more on that on the later panels. So I hope it answers most of the concerns, and if not, I'm sorry, but...
Thank you. Thank you, Mayor. Now is the time to open the floor for questions and remarks. So, are there any?
I have a question. So, thank you, Mayor, for the great presentation. So basically, I'm a constitutional theorist, so I'm trying to see this paper from that perspective. And my question is, since there is this whole debate on if constitutional norms are really legal norms, right? So basically, I want to ask, how does your claim fit into the constitutional spectrum? Like, how, what do you, like, how would you, because do you actually think that there is a difference between constitutional norms and legal norms? And in that sense, because I don't know if we can say that constitutional norms are really not truth value, that they don't have truth value. I mean, I cannot say that they have, but I definitely can say that they are somehow in that sense different from other legal norms. So in my sense, my question would be, do you think that your claim and your whole theory that you developed here can apply also to the constitutional norms or not?
Thank you.
Yes, if I may, but I would like to continue to that question, because mine was similar, just from another point of view, that's international law, and in regards to peremptory norms of international law. So you see, according to the Vienna Convention of International Treaties, a treaty, or let's say a part of a treaty, never mind, is void if at the time of the conclusion it is contrary to some other peremptory norm. So that is some kind of a legal inconsistency. Yeah. Are there some other remarks? Yes.
First of all, I really enjoyed your presentation. Congratulations. I will first start with precising when you said that there is a nature, the nature of law is logic. And I think that this can get us in some bit of a problem. We can use logic as a concept to understand or to define logic, or also to describe relationships between norms. The thing is, if we use logic to define what law is, we can get ourselves in some problems that are not trying to. For example, we cannot explain logic how two norms can contradict themselves from how we jurists understand it. This is an argument from Ross against the logic of norms. If we have a norm that says A and then obligatory to do something and A obligatory not to do the same thing, we have the same case but with two different consequences. This is not a logical contradiction because it follows that not the anticiple. So if we use logic to understand the law, we cannot explain how we, lawyers, because we will all agree that this is a case of a contradiction. It's the same person obligated to do two different things, contradictory things. This I think follows two conclusions. First, lawyers don't use logic as logicians do, and the second, we use logic to describe the relationship between norms, but not to define them. And also, and this is only a comment, if you use the framework of home right, you will have to assume also two big assumptions. First, that there is a rational legislator, which is a big assumption, And also, you will have to follow some monotonic deontic logic to explain all of this. First, are you sure that we must all, do you agree with the rational lawmaker thesis and why? And also, may it not be the case that monotonic logic, deontic logic is not the way of explaining the normative inconsistency that we have to use. So we have paraconsistent logic, the physical logic. And finally, when you clarify when you answer the clarification point between coherence and consistency, I think that you said that we can use both of these concepts to explain what conflict is and how we solve conflicts. I think I have understood this, that you can use the notion of coherence and consistency to explain normative conflicts and the way we solve them. If I understood you correctly, then and one is a logical conception and the other is a non-logical conception, you have by hand two notions of normative conflict, a conflict, logical notion of conflict, and a non-logical conflict. And by then, two ways of solving it. Can you precise what notion of conflict are you using in your paper? Thank you very much.
Also one short question, really short, it's just one phrase. Aren't we really stubborn thinking about law in a deductive manner? That's my question.
Are there some other questions? No? Maybe you can address them.
Good luck. Okay, so thank you all. These are great. I'll start from the last one because I think it's a question I hear often, and I think it's very good. And my answer to it would be, I am, but I think that you have to be stubborn if you want to. If you are serious about saying we have an objective standard, then yes, you have to take yourself as being stubborn. And my analogy to that usually is the development of physics. Physics has not always been something which is as grounded and as clearly, reflective of truth as we usually conceive. By the way, it's not even that way today, but the layperson usually thinks of that way. And when physically we say, look, A and B they're impossible, it's either or, right? There's a strong sense, there's a strong notion of, it's not because Peter is saying that, and it's not because I am saying that, it's because that is the case. So in that sense, I guess, on the one, if you take this analogy and you think about a different analogy, namely economics, then you see that the way systems structure themselves is correlated to the gains that they are able to glean in the sense of how compelling their conclusions are. So to your question, yes, I think that it is somewhat stubborn, but I think that if you really want to say we have an objective decision-making tool, I think you have to be. I think there's no middle ground. But I agree that that's quite a burden to carry. So I fully take the comment. I'll go back to the order and I'll try and answer Theodora's and Anna's questions. I'll start by saying that I'm not an expert on neither constitutional nor international law. So I don't want to be saying something too assertively here. Firstly, perhaps you could give me a clear example of what you have in mind when you say a constitutional norm rather than a legal norm, or in contrast to whether or not it is a legal norm?
Well, basically, there is this, for example, Waldron introduced this poll debate earlier, where it was like Hart and Austin had a debate on the question whether constitutional norms are, I don't know if you know that debate. So basically, I'm just, so that's my question. My question is like, do you think that this logic, do you even make distinction between different legal norms? Because I do. Like for me, constitutional norms are not the same. Don't have the same nature as, for example, tax law norms. So my question is, what do you think about that? And how, I mean, you don't have to fit that, as you said, like you're not dealing with constitutional law, so you don't really have to fit that. It's not like a comment or critique, I'm just interested from my perspective, what do you think about that?
No, absolutely, and even if it is a comment or critique,
no, I mean,
it's very
it
well.
doesn't really relate to that, but that's my, you know.
Okay. No, yeah, so now I understood what you mean, and I definitely am aware of Justinian constitutional law is just a positive morality kind of idea. So yeah, of course I think it is part of legal norms. It's a good question of how you circumscribe the area of what you call legal norms, and it's even a better question what you later on mentioned, that whether or not all legal norms are, as it were, of the same kind. To be frank, I don't have a good answer because I'm not sure. Intuitively, I would say that at least you'll have a grain of some kind of a form of legal norms with which you could work. And I mean, once again, that's a very intuitive response. I don't want to jump into any conclusion here because I definitely need to think about that. And with regard to international norms as well. So I'm sorry about the uncertain flavor of my response, because I think it's a very good question. I think it's a good question whether or not you take, for instance, tax law norms to be similar or even identical with other kinds of norm. Ultimately, I think that to the extent that you circumscribe a legal system, to the extent that you have a valid test of what is and what is not law, you're going to have at least some tentative understanding of a shared form, and therefore of a minimally shared legal logic. That's my tentative response to both questions. Moving on to Victor's set of questions. So these are all very, very good, and I don't think I have complete or final answers to them, but I'll try to, as it were, engage with them. I'll start with the last one, between coherence and consistency. So you're absolutely right that I think that there's a division of labor between two ideas of pattern in law. The problem is that I think that this division of labor is often overlooked. Often commentators use interchangeably both notions, as you would absolutely know working in the field, and you have people just saying, well, you know, this is consistent in principle, no, this is coherent, no, this is incoherent. Sometimes you hear words like incompatibility, and anyways, just words floating in the air, not necessarily we have an idea what exactly they mean and so on. That's part of my protest, actually. Now, yes, I do think that the notion which we should use in consistency discussions is a logical one. And this renders me vulnerable to your two other questions, which I think are good questions. So, in the logical nature of law, like I share your question. I myself ask what precisely should be that nature, whether we can define it minimally, whether we should distort or, as it were, warp or translate logic to our endeavors. I think that's not a good idea, but many people, as you would know, do that. Hare, by the way, being one. When Hare says you can ground logic not in truth, in something else, some people have said that it is unclear what he's offering. Otto Weinberger does the same, and I mentioned him in the paper and so on. So to your question, it's a very good question which I don't have a clear answer to. And to your final remark about von Wright's solution, so I completely share both your misgivings, and this is part of the reason that I'm not convinced by von Wright. And as you would probably know, many people are. And his solution is supposed to be the prime solution in the area. What I try to show is, beside the two objections which you raise, there are other objections which should lead us to ontologically question whether or not he really has solved the problem of a logical norms. So I hope it answers.
Thank you, Mayor. I do find this practice of two commentators quite convenient. Maybe we should make it regular, especially when the topics are so thought-provoking.